Welcome to What's Brewing with IAT Insurance Group, where episode after episode we cover the latest marketplace trends with subject matter experts who are fueling our mission to provide insurance answers together. Grab your cup and let's settle in.
Hey everyone, I'm Mike Zurcher and welcome to What's Brewing. I'm the EVP of Surety here at IAT, and I'm here with two of my friends and colleagues, Frank Tanzola, our Senior VP of Claim and our Chief Legal Officer, and Adrian O, our Senior Vice President and Chief Underwriting Officer of Contract Surety. Today we're going to talk about the Pennsylvania Supreme Court's Eastern Steel decision, which is one of the most significant surety rulings in recent years. In this episode, we will discuss the case and what the ruling means for sureties, contractors, and bond producers moving forward. Frank, we're going to lead off with you today. Can you take us through the case and the ruling?
Absolutely, Mike. I'll try to be as succinct as possible, which is going to be a challenge, but we bonded a project involving the construction of a new sciences building at Penn State University many years ago. So many years that building probably needs to be replaced by now. But in any event, the claim here was a claim by a subcontractor that installed rebar in the building, and their claim was disputed from day one by our principal. The bond form that we issued here was the AIA, or American Institute of Architects 312 payment bond form, which is a very common payment bond, perhaps the most common in the industry. And that bond requires the surety to respond within a certain time frame, pay any undisputed portions of the claim, and state its reason for disputing and not paying any other portions of the claim. And there's no question, and there was no issue, that we did that here within the time frame required by the bond. We responded and we paid the undisputed portion of the claim and explained our reasons for disputing the remainder of the claim. The claimant proceeded to arbitration against the principal in accordance with the terms of their bonded subcontract. The principal defended the arbitration, of which we were not a party, and in fact, our bond specifically required that any claim against us be litigated in a court in the jurisdiction where the project was located. The principal defended and contested the arbitration up into a point where the principal filed for Chapter 11 bankruptcy. Ultimately, the claimant obtained relief from the automatic stay in the principal's bankruptcy, allowing it to proceed with the arbitration, and immediately thereafter it went to the arbitrators and obtained a judgment against the principal in absentia. For part of what it was claiming, not for everything. The claimant ultimately filed suit against us, seeking to recover that, and also for bad faith under the Pennsylvania bad faith insurance statute, which this claimant has a history of pursuing such claims, even though every court that's considered them held that the Pennsylvania bad faith statute did not apply to sureties. In fact, the Pennsylvania Supreme Court had never decided that issue. So we'll fast forward to the Supreme Court opinion. That's the subject of discussion here. And they decided essentially three issues. And I think I'm going to address them in what I would characterize as descending order of importance. The most important being whether the Pennsylvania bad faith insurance statute applies to surety law. and the Supreme Court of Pennsylvania, as the appellate court did here, emphatically held that it does not apply and there is no bad faith cause of action against sureties, applying Black's Law Dictionary standard definitions to the terms in the statute and basic laws of statutory construction, where the intention is to determine what the legislature intended, which was that the statute applies to insurance and not surety. And they also cited to the very famous surety case of Perlman versus Reliance Insurance Company, which established the doctrine of equitable subrogation in surety, as well as emphasizing the traditional distinction between insurance and suretyship, which is a third-party guarantee as opposed to a direct obligation from an insurer to an insured. One thing I have to emphasize here is there was no indication that the surety in this case was International Fidelity Insurance Company, because again, the project and the bond goes back a long time. There is no indication that International Fidelity committed bad faith here. Quite the contrary. As I said previously, we followed the bond, paid the undisputed portion of the claim. Ultimately, we offered also to pay the portion of the claim that the claimant was awarded against the principal in the arbitration, even though our position, and I'll explain that in more detail later, is that the arbitration was not binding on us. The principal, in fact, we tendered a check. Okay, they rejected the tender because, and I have a lot of facts to back this up, they were driven from day one by their desire to pursue bad faith damages. And in fact, they're pursuing such damages against several other sureties currently in various jurisdictions. So on the bad faith issue, which again had never been decided by the Supreme Court of Pennsylvania, that is now settled law in Pennsylvania. There is no bad faith cause of action against sureties under the Pennsylvania bad faith insurance statute. On the issue of attorney's fees, it was a mixed result. The bond defines the surety's obligation as paying for labor, materials, and equipment. There's other provisions of the bond that use the phrase sums justly due, but under what I would say is proper contractual construction, where each provision of the contract is considered and given effect, the portion of the bond that refers to sums justly due is defined within the context of the surety's obligation to pay for labor, materials, and equipment, and nothing else. Unfortunately, the Supreme Court of Pennsylvania decided that where the subcontract between the principal and the claimant allows the principal to obtain attorney's fees, then the surety is liable under the AIA 312 bond for the claimant's fees incurred in pursuing the principal, but not for the fees incurred in pursuing the surety. That was a very key ruling for us in this case, because the vast majority of the attorney's fees incurred here were the fees that the claimant incurred in pursuing the surety over the course of years subsequent to the default arbitration award they obtained against the principal, again driven by the pursuit of the bad faith claim and unwillingness to settle that, which, again, even if the Pennsylvania Supreme Court had held that there was a bad faith cause of action against sureties, which they did not hold that, there would have had to be a trial on the bad faith issue. And I have no doubt we would have prevailed in that as a matter of fact. Fortunately, we prevailed as a matter of law. Again, on the attorney's fees issue, it was a mixed decision where we were held liable for the principal's attorney's fees incurred, or rather the claimant's attorney's fees incurred in pursuing the principal, but not the fees they expended in pursuing the bond claim. On the last issue, as to whether the surety is bound by an arbitration award against its principal, the Supreme Court held that we were bound by the default arbitration award against our principal here, relying on a very old case that was factually distinguishable from our case in that it involved, first of all, a performance bond that incorporated by reference the subcontract in that case. Our payment bond did not incorporate the subcontract in this case, and it's that contract that contains the arbitration clause. So a very important distinction is that in the case the Supreme Court of Pennsylvania relied upon, the contract requiring arbitration was incorporated by reference in the bond. Here it wasn't. And furthermore, in the case the Supreme Court relied on, there was no bond provision stating that the exclusive forum for pursuing the surety was in a court of appropriate jurisdiction. Our bond did contain such a clause. Nevertheless, the Supreme Court of Pennsylvania held that the arbitration was binding. So it had no impact here because it amounted to the same amount that the claimant was ultimately awarded under our bond. But as a matter of precedent, sureties have to proceed with the understanding in Pennsylvania that they will be bound by an arbitration award against their principal. And that essentially summarizes the holdings in the case.
So you've given us some details on the ruling and noted that the court ruled that Pennsylvania's bad faith statute does not apply to surety bonds. Can you give us a little bit more as to why this is so significant?
Well, the importance of the decision in terms of the bad faith issue is, again, that the Supreme Court of Pennsylvania had never considered the issue. And on a matter of state law, the highest court in that state is the ultimate authority on interpreting state law. So, for example, there have been prior federal district court decisions holding that there is no bad faith cause of action against surety bonds in Pennsylvania. However, the basis of those decisions are what the court believed the Supreme Court of Pennsylvania would hold had they considered the issue. So it was a matter of federal courts trying to surmise how the Supreme Court of Pennsylvania would rule. Now they have ruled. The same thing with lower courts in Pennsylvania. It's very clear now the highest court in the land has ruled in a recent decision that there's no bad faith cause of action. So, sureties in the future shouldn't have to litigate the issue for 10 plus years with appeals like we did here, because it's now been decided by the Supreme Court. So it's very important. It'll be much easier for sureties to dispose of these claims based on a judge motion to dismiss on the pleadings. And so it's a very significant decision. The attorney's fees decision, I think Adrian will talk a little bit about how that could be addressed by the industry going forward, but it's going to be very dependent on the language of the bond and the claimant's subcontract as to whether and to what extent bond claimants can recover attorney's fees in Pennsylvania going forward.
Hey, Frank, great segue into underwriting. Adrian, how do you view this from an underwriting perspective, and what does this mean for sureties operating in Pennsylvania?
Well, Mike, I'll just start out by saying, since I'm not an attorney, I will tell you my responses will be shorter than Frank's. So I will give you the answer to your question from a business and underwriting standpoint. It's really good because it doesn't expand our responsibilities beyond the intent of the surety bond, which is really to pre-qualify contractors and stand behind their performance and payment obligations on a construction contract. In short, it really limits our exposure and allows all sureties really to focus on the true intent of a surety bond, which is to pre-qualify and stand behind and honor the obligation of our client when they enter into a construction contract.
So, Frank, going back to your earlier comments, you noted that the court also held that sureties may be bound by arbitration awards against their principals. What does this mean in practice?
Well, I think it means that if there's an arbitration between the surety's bonded principal and a claimant, whether that be a payment bond claimant or the obligee under a performance bond, the surety has to monitor it to ensure that its principal defends that arbitration and continues to defend it. And that if the principal doesn't, the surety needs to intervene and raise any defenses that it believes are appropriate. Again, in our case, I think we had good reason for not intervening in the arbitration due to the terms of our bond, which were very clear to us that we were not obligated to arbitrate, and in fact, that the sole forum for asserting the claim against the bond was in court. And in fact, there was a dissenting opinion in which two justices joined that would have held for us on all issues, including the arbitration. And in fact, there was a comment that the majority's opinion here was an affront to International Fidelity's constitutional right to a jury trial, which we specifically reserved in the bond, and again, did not incorporate a contract that had an arbitration provision. But now we know what the law is in Pennsylvania. I would say, too, as far as the attorney's fees issue, the practical implications worked out well for us because, again, the fees that the claimant didn't get exceeded by probably a factor of 10 the fees that they incurred in the arbitration and were awarded in pursuing the principal. But I think sureties might want to consider doing a modification to the AIA 312 bond that makes it clear that despite the use of of language in two places referring to sums justly due, which I think was taken out of context and misconstrued, but making it clear that under no circumstances is it the intention for the surety to be held liable for attorney's fees other than under the paragraph of the bond that requires to respond in a certain amount of time and pay any undisputed amounts. And that is under the AIA 312 bond intended to be the sole way in which a claimant can recover attorney's fees. And so I think in light of this decision, that needs to be clarified. And the AIA 312 bond does include a means for modifying it. And I think sureties should seriously consider taking advantage of that wherever possible. And in other situations where there's a different bond form, they have to carefully review that language. And I think bond principals need to be very careful of what language they allow in their subcontracts. And, honestly, if there was one overriding reason that I wrote the article, it's really to send a message to our agents and principals that if our principals allow attorney's fees provisions in their subcontracts, that could end up coming back against the surety. And keep in mind, contractors don't normally personally guarantee their subcontracts, but they do personally guarantee their obligations to the surety. So I think that message should be delivered to them so that they're very careful, because if they have language like that on a bonded project, they could be putting all their personal assets at risk.
Thank you, Frank. And so continuing on that theme, Adrian, looking at this through the lens of an agent and producer, what kind of conversations should our agents and producers be having with their contractor clients?
Yeah, and I'm going to repeat some of the points that Frank has already made, but I think it's important for our agents and our customers to hear it. Key item is starting out is that contractors and agents should be having open lines of communication with their surety companies when they enter into contracts in the state of Pennsylvania that require a surety bond. A starting point for contractors and their agents is to make sure that they're reviewing the contract language and the bond forms. And it's important to review both, because the bond, even though it may be silent on certain obligations that the contractor and the surety may have, the bond covers the contract to the point where if there's any confusion or any gray areas, the customer, the contractor, and their agent should involve their outside counsel to review the language in both the bond form and the contract to make sure that they have everything covered. An important part in the process is if there is a dispute on a project between a contractor and the ultimate owner, the important part is for them to bring the surety into the discussion at the outset of the problem so that we can get involved and provide our input. Many cases, the earlier that a surety gets involved in a problem that a contractor may be having, whether it's state of Pennsylvania or anywhere else, but especially with the language and some of the expanded obligations for all parties in the state of Pennsylvania, the earlier we all get involved and work together, the better the outcome is going to be for everyone.
Thank you, Adrian. And Frank, one final question for you. What do you want to leave our audience with? What are your final thoughts on all of this? It's clearly a very complex case from a legal standpoint, and it, as a result of that, it makes it even just as complex from an underwriting standpoint. But what would your final thoughts be here that we want to leave our listeners with?
Well, I would emphasize the importance of the ruling that there is no bad faith cause of action against sureties in Pennsylvania. And of course, that doesn't mean that sureties don't hold themselves to the same high standards in adjusting a claim as a liability insurance carrier, personal injury, or any other field. However, there is a distinction in terms of the surety being a guarantor of another party's obligation, which party also has rights, and the surety has to consider that party's position as well. And as long as the surety investigates thoroughly and makes a decision and communicates that decision in good faith, there shouldn't be an issue. However, as we see in this case, sureties can be dragged through costly litigation. So it's certainly a very positive thing for the industry that question is now settled favorably in the Commonwealth of Pennsylvania. And but I would have to caution that I think the attorney's fees aspect of the decision has gotten a lot less attention in the industry. And, I would just caution there that the very real possibility of the surety being liable for attorney's fees and prejudgment interest, depending on the bond language and contractual language, has to be very closely looked at by sureties, agents, and contractors.
Well, thank you both for your insights and for your time today. Thank you to our listeners for listening to What's Brewing. We'll see you all next time.
Providing insurance answers together is what we do best. Thanks for tuning in to the latest episode of What's Brewing. Until next time.